Trade Union Solidarity last week brought an application to have national carrier South African Airways placed in business rescue. Werner Human, the Deputy Chief Executive of Solidarity, joins me from our Pretoria studio. Thanks so much for your time on SABC News. Take us through the reasons for your application.
Good afternoon and thank you for having us here. Solidarity had considered business rescue application for quite some time. We had the application ready last year. We were approached by Mr. Muziwakhe Zwane to enter into discussions with SAA to see if we can have some solution outside of a formal application. For Solidarity, it's not about launching an application for the sake of launching an application. We earnestly tried and attempted to find some or other resolution. After that, Mr. Zwane resigned. We have prepared our application again, and we saw the SAA board, and we also saw Minister Gordhan. The recent developments as SAA shows that we have got no other option as to institute the business rescue proceedings which we have. We believe that would be a stabilizing effect on SAA. They are in desperate need to find some form of stabilization, and there's no other option. If it goes on like it goes on present with SAA, it would mean that the entire airline as a whole and all of its employees will suffer, and it will have to close. We are trying to save as much as we can in SAA.
Take us through the legal standing that one needs to have in order to bring forth such an application, and talk us through Solidarity's application and where that falls in line with the Companies Act.
First of all, a very important matter to note is that the SAA is indeed subject to the Companies Act. It has been designed as such to hold SOEs accountable. So within the legislation, SOE like SAA, like Eskom, like the other SOEs as well, are subject to the Companies Act. Secondly, in terms of Section 128 and onward from the Companies Act, if you are a registered trade union, you do have locus standi to approach or to institute business rescue proceedings. Actually, what ought to have happened, the SAA board should have done this. They have not done this. The Act is explicit on it. When you are in financial distress, that is the resolution you ought to take, and they have not done so, and they have not provided reasons as to why they have not. But we are within our locus to bring this application. We are a registered trade union, and most definitely SAA is in financial distress, and it's deepening literally by the day. The last financial year they had about a 6.5 billion, estimated 6.5 billion rand operating loss. They have already had 33 billion rands of debt, and they want another 21 billion rand. This is not sustainable. You need something radical, which is interventionist and would challenge the status quo proceedings.
Practically, what would this business rescue mean for SAA if you are successful in your application?
There's a few consequences once you have this application. One of the consequences are that there's a moratorium on legal proceedings against a company. In this case, it would be SAA. This is of worth because it means that there won't be adverse claims or court actions against once you are under business rescue. A further thing, that your property, the property interests of SAA would be protected under business rescue. It would mean even though SAA is in lawful possession but not the owner of property, it will mean that it may remain so. Very importantly, the business rescue practitioner may renegotiate and suspend certain provisions and contracts which SAA had entered into. And this is a way in which to stabilize the environment, stabilize SAA, and trying to find a solution, a business rescue plan for the SAA. Our application has been launched. The process now, there would be some form of consultation with affected parties that received notice. This includes trade unions, this includes the Department of Public Enterprises, it includes Minister Gordhan, and now it would see what would be the reaction of the minister, what would be the reaction of the trade unions. We believe where SAA is now is the fault of SAA and SAA alone. They should not oppose this step, they should welcome it, and we want to have build on this new process a way in which we can find a solution. They ought not to oppose, they should welcome this step.
So if your application is successful, it's my understanding that it'll be the first time in the history of our democracy that a state-owned company would be placed in business rescue. Are there plans to approach the court for more interventions, and what are you hoping for?
It is indeed historic. It is a historic applications. There are about 200 registered SOEs, and if you look at the state of our SOEs, an application like this was wanting. So what we would want to achieve is quite a few things. Firstly, on SAA itself, we would like to have a rescue plan adopted, a rescue plan agreed upon by all parties that would be for the benefit of the SAA, and very importantly, it's 11,000 employees. Without this application, we think that option is out of the window. So we would want a firm and sustainable way for SAA to be saved as far as it can, given where we are now. Furthermore, we should have a discussion, we should have a national discussion what the role of the state should be in our state-owned enterprises. There's not a single state-owned enterprise which is truly in a formidable state, which is growing and which is really doing what they ought to be doing. We need to have a discussion whether this is still viable. As an example, in SAA, it's not anymore practice that a state must own the entirety of an airline. That doesn't exist anymore. There are other airlines where this has failed dismally, and where they have changed is where they've changed the ownership structures. It doesn't mean that the state doesn't have any say anymore. It means that a wholly state-provided institution like an SOE, like SA, is not anymore feasible or sustainable in any sense of the word. The red tape involved in that is overwhelming. You cannot make decisions. The money needed to keep it afloat is enormously high. We need to think differently. So as a secondary outcome, I think a discussion about what the role of the state should be part of the outcome which we have.
Werner Human, the Deputy Chief Executive at Solidarity, thanks so much for your time. He was speaking to us live from our Pretoria studios. Let's continue this discussion now with Muziwakhe Zwane. He's a business rescue expert and he joins me in studio now. Thanks so much for your time on SABC News. Perhaps you can give us context of what business rescue is and when it needs to be implemented.
Thank you, Nzinga, for having me, and hello to your viewers at home. So, business rescue is a process that was designed to assist ailing companies. And the idea behind it is twofold. So you have the first objective of returning a company to a state of solvency, and then you have a second objective of securing a better return for creditors in the event that the company cannot be returned to a state of solvency. But that's sort of putting the cart before the horse. How do we get there? And how we get to a situation of business rescue is if a company is said to be in financial distress. So Chapter 6, which is the chapter in the Companies Act that deals with business rescue, states that a company is financially distressed in two different kinds of circumstances. The first one is if it is foreseen that the company within the immediately ensuing 6 months will be unable to pay its debts as they become due and payable, or if it is perceived that within the immediately ensuing 6 months the company will be insolvent, or its debts will exceed its liabilities rather. So it's what we call a solvency or liquidity component to determining whether or not there's financial distress. So once we have determined that, then the board can pass a resolution placing this company in business rescue, and then there must be prospects, however, of rescuing the company, and the rescue is, as I mentioned earlier.
So the Companies Act, as we've heard, allows for exemptions of state-owned companies from parts of the Companies Act.
Okay.
So I'm assuming that this would mean that sometimes they would be exempt from processes like this, or is that an incorrect understanding? Okay.
So I think from there, let me take you to Section 8 of the Companies Act. So Section 8 of the Companies Act stipulates what a company is, and that's what business rescue applies to. So a company is divided into private companies, or private or public companies, and as well as those would fall under the purview of profit companies, and then non-profit companies. So the profit companies will then include also the state-owned companies. So it's clear from that definition that the Companies Act and the business rescue provisions would apply to SOEs. But then Section 9 then provides an option for certain provisions of the Companies Act to not apply to SOEs. But this is not a blanket provision. It's a provision that applies within the purview of Section 5, subsection 4, and Section 5, subsection 5 of the Companies Act. So those provisions stipulate that the Companies Act is applicable to SOCs, and if in the event that there is a inconsistency between two provisions that are applicable to one particular entity, then those provisions must be applied simultaneously. If it is inapplicable to be supplied or to be applied simultaneously, then certain provisions then countervail over the previous one. So, for example, the Labour Relations Act its application cannot be limited. The PFMA Act, its application cannot be limited as well. So you find situations where maybe because of the provisions of the PFMA, the Companies Act's limitation ought to be limited so as to not impinge on that. But in this instance, it has not been passed. The Minister has not provided any provisions to limit the applicability of the Companies Act, Chapter 6, to SOCs.
So as it stands, SAA is subject to business rescue. We have reached out to Treasury to ask about whether SAA has been granted this exemption. They haven't gotten back to us yet, and we did call quite early on. So what does that mean? That means someone can, like Solidarity, can go to court, can apply to place a state-owned company like SAA because it fulfills the reasons that you've spoken about in business rescue.
So conceptually that can be the case, but Section 131 of the Companies Act provides a limitation as to who can bring these sort of applications. So in order to place a company into business rescue involuntarily, this is through a court application, this application needs to be brought by an affected party. So an affected party is defined in the Act as either a shareholder of the company, as either an employee of the company, or a registered trade union of the company, or a creditor of the company. So it's limited to those particular parties. So they can bring this application, and the court can grant this application in instances where it is just and equitable to do so, just and equitable for financial reasons, or if the company is financially distressed, or if the company has failed to make a payment in terms of a regulation or a contract that relates to employment. So now in the instance of SAA, for example, you're seeing that the board has indicated that there might not be funds available to pay salaries. So that's clearly falling within the purview of bringing such an application.
Could we see then SAA, if let's assume they're successful in their court application, being placed under business rescue and having someone outside of the state coming in and deciding what can happen in terms of creditors and renegotiating the agreements, as we've heard about a little bit earlier?
Conceptually, that is quite possible, and I think that's one of the groundbreaking aspects of this case, is that applications to place a company under business rescue are rare in and of themselves. So now we are put in the situation where it's not only the rarity of that application, but it's the fact that it's an SOE, and that could have dire not only political but social ramifications. But I think what this also does is that it sort of reveals an added bow in the string of civil society in its attempts to acquire a certain level of accountability within the SOCs. But as I mentioned earlier, the Act does place limitations on who can bring these applications, and I think we should be guided by that. But there's some very interesting jurisprudence that's coming our way in this regard.
We'll be watching that story and hopefully speaking to you later on as this application progresses. Thanks so much for your time on SABC News. Muziwakhe Zwane, business rescue expert, joining me in studio there.